Hello, everybody. My name is Matthew Dobler. I am a lawyer with the law firm of Probanek and Probanek, and I've also got this YouTube channel where we focus on getting better at practicing law on Zoom. I was in an Allegheny County Bar Association civil litigation section committee meeting today, and there was a development that I wanted to share. It affects both online litigation and practice in all of Pennsylvania, so I thought a video would be simplest. Judge Ward, who is our civil administrative judge, reported about an email state court trial judges recently received from the Pennsylvania State Supreme Court. According to Judge Ward, this email essentially ended remote litigation in Pennsylvania state courts. It apparently directed trial courts to return to pre-pandemic operations, and it made allowance for remote proceedings only where either authorized by existing rules or when required by exigent circumstances. Now, according to Judge Ward, family court is the only division where existing rules would support any type of online proceeding, so they are essentially no longer authorized. She specifically said that the email required judges, lawyers, and parties to appear in court in person. Somebody in the meeting asked if this prohibited expert witnesses from testifying at trial via Zoom, and the thought was that this type of testimony would still be permitted, but Judge Ward went so far as to mention status conferences and discovery hearings as examples of proceedings that could no longer be held remotely. So, in the first instance, those of you who practice in Pennsylvania, you should be aware that remote proceedings are apparently no longer authorized. Obviously, my personal opinion is that this is a bad choice which will have negative consequences for the practice of law in Pennsylvania. Remote proceedings are not appropriate for every court hearing, but they are certainly a valuable tool for some, if not many, court appearances. During the pandemic, we learned that in many instances, remote proceedings were less expensive, more productive, and more convenient. They benefit clients, taxpayers, and the public interest. I've even had one interview with a lawyer from the Department of Justice who made a convincing argument that the obligation to inexpensively resolve disputes required courts to prefer remote proceedings or to justify why the added cost was necessary. That's a fascinating interview, and I will put a link of it in the discussion of this video. Short of that extreme, though, other states are continuing to develop these cost-saving technologies. The state of Washington, for example, continues to hold many routine proceedings online, saving parties untold fortunes in litigation's fees and costs on an annual basis. This decision serves only to pad the bills of lawyers who must travel to court and sit and wait for their case to be called. Nobody else benefits from such a broad prohibition against remote practice. I encourage measured and respectful opposition to this decision. Remote proceedings do not need to be mandatory, but they should be permitted. In fact, a rule prohibiting them, as this email appears to represent, seems short-sighted and overly prescriptive. I encourage you to discuss this matter with your local bar associations, trial teams, and trade groups. Remote proceedings save everybody money, and the Pennsylvania Supreme Court needs the input of users of the court system here. Again, the outcome shouldn't be to require remote proceedings, only for permission for remote proceedings to occur. Of course, I care deeply about this issue, and I'm happy to chat with anybody. Put your thoughts in the comments to this video, reach out to me to Zoom together, or shoot me an email. But keep the conversation going. Keep me in the loop and use this video to spread word on this issue. Thank you.